Mr. Chairman. On June 24th, the Supreme Court's radical conservative majority made clear that they were not only gutting 50 years of women's established constitutional rights to make their own reproductive decisions, but that abortion was just the first on the laundry list of rights that they were prepared to eviscerate. The right to privacy and intimate relations, the right to raise your children how you see fit, the right to contraception, the right to same-sex marriage. And when people talk about the radical advocates, as my colleagues on the other side of the aisle have described, I am a radical advocate for personal freedom and individual liberty. And our democracy is premised on a notion of basic individual autonomy. We don't let states or even the federal government take away rights that the Constitution establishes. And so it's not a question of do we trust states to do it, it's do we trust the individual, and in this case it's women, to make their own healthcare decisions. But it's astonishing to me that anyone who has read this decision is not worried about many other rights that are at issue and that are in danger. Regardless of what your political party is, regardless of what your view is on abortion, there are lots and lots of rights that are also at risk. And so I hope all of America is paying attention to this decision because your rights, well-established freedoms, are hanging in the balance. And that brings me to my first question. Ms. Warbeloff, thank you for your incredible work, for your testimony. And thank you, Mr. Oberfeld, for your really compelling testimony, for your courage and bravery in helping to bring marriage equality to millions and millions of people in this country. You know, if you look at Justice Alito's adherence to a legal philosophy known as original intent, which involves examining the founding documents language to derive meaning on contemporary issues, can you explain why this method of legal reasoning is outdated and antithetical to a modern society, particularly to members of the LGBTQ community who has historically been discriminated against, and if you follow that reasoning, may never live in a country where they can live lives free of discrimination? And finally, would the Equality Act address that?
You know, first, it's important to note that it's very difficult to discern original intent. We cannot always know what is in the mind of a legislator when they pass a law. And in fact, people may have conflicting reasons for passing a law. That's why basing on original intent, whether it's a piece of legislation or a constitutional amendment, is a flawed approach to legal analysis. Beyond that, taking that approach continues to privilege those with power. And individuals, LGBTQ people, people of color, particularly Black and brown people, people with disabilities, and women will continue to be disadvantaged if we are always taking into account what was written more than 2 centuries ago by white men who were interested in maintaining control of society rather than sharing equality with all.
Which, as Delia Lithwitz, I think, so eloquently said, this move cynically weaponizes a deeply rooted history and tradition of little protected liberty and vast inequality to eradicate the modern jurisprudence of American liberty and equality, which is exactly what you just said. Professor Murray, under Roe and Casey, the right to abortion was implicitly read into the 14th Amendment due process clause and obviously was deemed a fundamental right. In Dobbs, Justice Alito rejects this approach, reasoning again that only rights that are deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty are fundamental rights. Again, what are the implications of adhering to this logic for other rights, and specifically, what would the impact be, in addition to that, on in vitro fertilization if state abortion laws are interpreted as granting fertilized human eggs legal rights and protections?
Thank you for the question. Let me reiterate, the right to choose your procreative future is not just implicit in the guarantee of liberty, it was actually explicit in the 14th Amendment's ratifiers' views of this anti-slavery amendment. So it proceeds from that ethic. And it does have important repercussions. Overruling the right contained in Roe does have important repercussions for in vitro fertilization. As you know, part of the in vitro process often requires the selective elimination of embryos. And so there are lots of questions about whether or not this limitation on the right to procreate could have broad repercussions for assisted reproductive technology, including ART and IVF.
Thank you. And Mr. Chairman, I would ask unanimous consent to introduce in the record the United States Freedom in the World 2022 Country Report. because sadly, America is less free than it was just a few years ago. And so this isn't a question about what we think. This is a report that shows we've slipped. America is less free. The Supreme Court is attacking our freedoms. We need to stand up and codify everything we can to protect all Americans so they can be free from discrimination of any kind and recognize the autonomy of every single citizen.
Without objection, and the time of the gentleman has expired, Mr.